Professor Rycroft is very experienced in the area of alternative dispute resolution, and he's also a part-time senior commissioner at the CCMA. The reason why I've asked him to do this presentation this morning is to assist you, the panel members and chairs of panels, with the writing up of awards. He's not so much going to focus on WADA and the WADA code, but I've asked him to focus on disciplinary inquiries, the aspects that chairs should be aware of, and also to focus on the writing up of awards and to give you a sense of how you should go about preparing those awards. So thank you very much, Alan. Alan is going to call the coffee break at his convenience.
Thanks, Rochelle. I'm going to start with an immediate disclaimer that I feel very much like Daniel walking into the lion's den here. I'm definitely a Labour arbitrator and I know very little about sports law, so I'll be relying on you to correct me when I stray. Now you agree to do these presentations long in advance, and as the time creeps up, you wonder why Rochelle asked me, and I think it's because actually quite a few of my arbitral decisions have been taken on review to the Labour courts, and so I have developed some expertise in trying to insulate my awards from being reviewed. So I think that's really why she asked me. But it's very good to be here and to meet a whole new crowd of people. Can I please ask that this session be as interactive as you like, and for you to add to things, and I think also, I haven't met Julian, but I'm sure he'll have a lot to say about my suggestions. It's almost inevitable in this country for us to think about what kind of decision is being made, and I'll get back to that. Then I want to look at what's required as regards procedural fairness, substantive fairness. I want us to look at the grounds of review, and finally I'll come to a suggested structure for the decision. I do that because the CCMA, which in this country is the Commission for Conciliation, Mediation and Arbitration, they have a very, I think, workable, quite a tight template for arbitral decisions, which allows, which keeps arbitrators on the straight and narrow, and that's what I'm trying to suggest here. So, the purposes of the decision. When you stand back and say, I'm about to write up the results of a disciplinary inquiry, what are my purposes? The first one, I think, is to explain the basis of the decision in a simple and understandable language. One of the judges who I certainly admire in this country is a judge on the Constitutional Court, Judge Edwin Cameron. And he's always made a point of saying his first obligation when he writes a judgment is for it to be understood not primarily by the lawyers and advocates involved, but by the person, the litigant, the person who's gone to court. They must be able to get this document and make sense of it. And he said he tries, quite an interesting rule of thumb, he says every word that's more than 2 syllables, he looks at it and says, do I need to use this word? It's quite an interesting discipline from a judge in the Constitutional Court. I have noticed he slipped since he got to the Constitutional Court, but his judgments before were known for their simplicity and so on. There's a famous judge in England, Lord Denning, who also had a similar approach. And one of his judgments started with the words, there was a ship. It was a big ship. Which gives you a sort of a sense of how he tried to keep his judgments simple. So I think one of the purposes is when the athlete gets this decision, it must be understandable. They must be able to follow it from beginning to end. Then to record the facts of the case. This makes it really important for people who decide whether to take it further, that they understand that there are enough facts down there to assess how this case is different from that case. To talk about a natural or juristic person, that's exactly what the institute is, other than an organ of state, when exercising a public power or performing a public function in terms of an empowering provision which adversely affects the right of any person and which has a direct external legal effect. you can see that the work of the Institute, it was created by statute, and so it falls very firmly into this category. So the work of the decision of a disciplinary committee is an administrative decision, which then falls into PAJA, which that's the promotion of administrative justice, the Act's name is abbreviated to PAJA, falls into PAJA, which then makes decisions have got to conform to the standards of that Act. This I need your help on. This is the answer I did after my research. I think it comes from this Act, the South African Institute for Drug-Free Sports Act, and so I went to the powers, and there's no power. It says the Institute has the power to have a disciplinary hearing. There's no power there, as simple as that. All right, so I had to look further, and I think it's these two sections. The Institute shall adopt and implement anti-doping rules and policies which conform with the code, including the wider prohibited list, and then also take other steps. Correct me wrong, am I right? This is where, I'm so glad I'm getting a few nods in the audience. This is where the power to hold a disciplinary inquiry comes from. All right, so this is not immediately apparent, do you understand? Because if you're looking for a section which says the Institute has the power to hold a disciplinary hearing, you're not going to find it. But it's implicit in that. If you are satisfied the person's been given notice and there's no explanation for their non-appearance, I think you can go ahead. But I'm willing to grant one adjournment, I must tell you, if I've got a doctor's certificate. Any comments on that? Am I talking sense there? I think to carry on without one of the parties is really dangerous. When it comes to substantive fairness, this is about substantive fairness. It's coming up black, not red. Okay, it's got in bold. I've got it in red here. But just look at what's in bold there. Written reasons, adequate reasons in writing, and here, if there aren't adequate reasons, there's a presumption. This is really interesting. A presumption that the action was taken without good reason. So, because the rules have got a distinction between the number of days you've got to give a decision and the number of days you've got to provide the reasons, if somehow that slips and just the decision's given, not the reasons, it will be taken in terms of PAJA to be substantively unfair. So I just put up there, I'm sorry the red isn't emerging here, it's just bold. But it's what it is saying is that reasons are at the heart of substantive fairness. That's the way people can assess whether this disciplinary committee has been fair or not.